thanks to Mike, and appreciate the invitation. But also, a major thanks has to go to Shihan Q. I think what most of us don't appreciate in our free society is that without the efforts of individuals taking a cause, no matter what it is, and running with it, investing in it, and then willing to spend the time and effort with it, we don't get a lot done. And that's true no matter what your views are, what side of the aisle you sit. We might have 3 aisles, it doesn't matter. In a world in which we depend on individuals, taking on a cause is important. Now, the cause was not someone else's, it was his own, so it makes sense. But we had many discussions, I will tell you, about whether we go forward. Why? Because Shihan, Zen Magnets, was fighting, quite literally, City Hall. In this case, it happened to be one of the largest city halls in the world, the United States government.
We were in 3 simultaneous legal battles with the federal government. They were trying to ban magnets. We were in fisticuffs one-on-one with the CPSC, and during that, they also banned magnets, basically like trying to kill our income. They were trying to make sure we couldn't breathe in the middle of this boxing match.
So in August of 2012, Shihan contacted me based on a mutual friend who I think saw an article in the Denver Post, and I don't remember if my friend told me to call Shihan or Shihan called me. I don't remember that detail. But we did meet at my office, and he explained to me what was going on. What was going on? The Consumer Product Safety Commission had issued a stop sale order to his business after having come to the business and looked around and seeing what the product was. The subject product was these small, high-power magnets. When I say high-powered, understand what I'm talking about.
How many of you guys know what the product is, has seen it? That's the idea. So not all of you. Okay, nice. Got some magnets right there, yeah. Small, yes. Small rare earth magnet balls that you can build all sorts of things with. They are, a lot of people get really deep in them. They are as easy to pick up as Lego. They are as expressive as clay. It can be as deep as origami, and it can be as frustrating as trying to build houses out of playing cards.
You have magnets on your refrigerators, or you have magnets you use for some things. These are magnets that are so strong that they will find each other if swallowed. Now, the flux of a magnet is what we measure. Okay, the measurement of magnetism generally, and Shihan might be able to tell you the science a lot better than I, although I've learned a little bit in the last 6 years. We measure the strength of the magnetism by a thing called flux. So your refrigerator magnet has about a 50 flux. These were upwards of 450. They're very strong. Very strong. So what? So if I swallow one, that's why it's like swallowing anything, and it'll probably pass through. But if I swallow 2 or more, they will find each other because they both have that strength. And if they find each other and one is on one side of a stomach wall and one is in the stomach wall will be perforated. It's a very serious problem. There were children who had swallowed some of these magnets in 2010, 2011, and the incidents were brought to the Consumer Product Safety Commission through their procedures. And I won't go through all of that because I only have a certain amount of time. So that case then was brought to the CPSC through basically a doctor in San Antonio named Dr. Noel. It was a very serious case. And so that got the Consumer Product Safety Commission to get working on this because it was serious, it was bad, it was terrible. And in law school, one of the first things we learn is hard cases make bad law. What do we mean by that? The emotional cases, the tough ones, the things where it just shouldn't be that way. So the old cases of an engineer losing his arm doing coupling of 2 freight trains by hand, which is how it used to be done. So we must have had to have a law. You have to have a law because we can't have people losing their arms while putting trains together. And it burgeons from there. And through the industrial age. And through the industrial age, there have been many things that have happened to people, the cost-benefit of our world.
Let's consider the entire universe of consumer products that are available. And if we were to kind of separate them into how dangerous they were, let's say on one end, there's products that are meant to be harmful. Products where like a important component of value is their ability to cause harm. So for example, guns or knives or tasers or pepper spray or most things that come out of the military industrial complex. Those are things that are meant to be dangerous. In the middle are products that are expected to be dangerous. Those are, you know, if you go on a trampoline, there's going to be warnings telling you that's extremely dangerous. If you go ski, similar warnings. If you buy a skateboard, you'll see stickers about how riding this is inherently dangerous. And basically any of those things where you have to sign a contract or, you know, you see a warning of that sort. And then the rest of the products are the products that are only dangerous if misused. Pencils, you know, you could misuse it, you could stab yourself or somebody else, but, you know, it doesn't really happen, and if you do it, it's your fault. Magnets go in here. They're only dangerous if misused. If, you know, you give them to a child who doesn't understand that it's a non-food. Other than that, they are perfectly safe.
Well, here, the Consumer Product Safety Commission got to work, and they've decided they're going to stop this terrible thing called these magnets without looking at any of the benefits. There was no cost-benefit, very little cost-benefit analysis. First, they tell Shihan and other companies, stop selling them because they're so dangerous. Some companies agreed. They were sold on the internet through Amazon and other sellers. They took them off. Shihan said, I'm not doing that. We can make this work so that I can still sell them. I understand the danger if someone swallows them. But gosh, I'm looking at all the materials here, and I don't see where it says to anybody to put it in your mouth. All right, why are you swallowing them? So we go forward, and again, I don't want to bog down in all those initial details, but so the Consumer Product Safety Commission then brought what's called an administrative complaint. Here, the Consumer Product Safety Commission is run by commissioners who are appointed by the President and have to be confirmed by the U.S. Senate. And so we were dealing with commissioners who felt that these magnets had to be banned and stopped. They have many vehicles, they have many tools at their disposal, one of which is an administrative complaint. They can sue any company or furniture company for tipping, room heaters, all right? This happens a lot. They're not safe. They, unfortunately, every year there are children who are seriously harmed or killed because of a localized heater. That's on the Consumer Product Safety Commission, all right? These magnets, because they thought they were toys, were also, they are a consumer product, regardless of whether they're called toys or not. So they can stop a sale. They have the right to do that. How does that happen? The United States Congress, Article 1 of the U.S. Constitution, the legislative branch, makes laws. They created the CPSC. By the creation of the CPSC, then they allowed the CPSC to promulgate rules to run itself. All right? So another tool at the CPSC's disposal is making a rule, which they did. In addition to suing Zen Magnets and other companies to stop selling and to do what's called a recall, to send back things that have already been sold. For instance, any of you own cars here? Have you ever received a recall notice? Ever received a recall notice from your car manufacturer? That is from an administrative agency, all right? Transportation Department, all right? Because of some problem in the car that's been found out. Now, so they can stop the sale, they can cause a recall. The other thing they can do is promulgate a rule through a whole procedure. It's called a rulemaking procedure. And for anybody who cares, it's an entire quarter or semester's course in law school called administrative law. And it's a whole body of law that deals with how agencies are run, which is different than the courts. Why? Because again, these are Article 2 creations, not Article 3 creations. Now, the reason I'm doing all that kind of grade school government is because we tend to conflate these things. When we're talking about this case, for example, we mess this up. We get it confused. Why? Because they brought this lawsuit called the administrative complaint. They promulgated a rule which said that no one could import these magnets. They're found and then refined in China and brought to the United States. That's what Shihan did. He imported them. Having dealt with a factory in China with his own specifications and knowing exactly what to do, with his mechanical engineering background, and it was beautiful. But once the CPSC promulgated a rule which became effective effective in September of 2014. It was promulgated in September 2014, became effective April of 2015. So we filed, there's a procedure, to take that rulemaking and challenge it in an Article 3 court. The procedure we had to follow was to take it to the 10th Circuit Court of Appeals, which we did. In November, so that's one piece of this case. The first piece is the administrative complaint, stopping the sale and doing a recall. Challenging the rulemaking, which prevented the magnets from being imported and from Shihan using them. Okay? Now, a third problem happened a little bit later. Why? Because how do we resolve issues with administrative agencies? We resolve them because everybody needs to ask, how do you settle the case? You always have to be able to settle the case, right? There's no case that always goes to trial, that always goes forward. You got to be able to resolve it. How do you resolve an administrative action? You resolve administrative action through what's called a consent decree. So representing another company, as well as other companies that I know about, those companies and myself, on behalf of that second company, entered into a consent decree with the Consumer Product Safety Commission. That consent decree had a clause in it that said you can no longer do anything with the magnets in your possession. Now, in a brilliant business move, Shihan said, before that becomes effective, I will buy from you, and I meant that. I was not being sarcastic. It was smart for Shihan to buy those magnets from one of the companies at a cheaper rate, because what are they going to do with them? They can't do anything with them. They were the same, essentially the same magnets, not to the same exacting standards that Shihan wanted, that came from China. So he said, okay, I'll buy those up. The Consumer Product Safety Commission was not amused in the least with this strategy. And so they sued him in what became a third case for us. Palm to forehead saying, you've got to be kidding me. These are the same magnets that he is allowed to sell right now because all this happened at a time when nothing had been resolved, so he could still sell them. It was before the effective date of the rulemaking. It was before we got a decision on the trial. So now let's go back. If you're following along, you're doing well, because it's quite complex, because we have these three cases. So we try, after a bunch of all kinds of stuff, and I tried first working with the CPSC to figure out a way we could do this. Essentially, they said no. There's no set of circumstances that we will accept whereby Zen Magnets can sell these magnets in a safe way. It is not possible to do. There's no warnings that can be done. There's no packaging that can be done. As soon as anybody touches these magnets, they will die. That was the attitude. That was the attitude.
We did ask them, we asked the CPSC what they wanted, and it's not like they were asking for some kind of gray area. They weren't willing to work with us on any kind of like warnings. They didn't want any kind of waivers or contracts signed. They wanted just a complete nationwide ban on these sorts of magnets. Didn't matter if you're an adult in an office, without kids around. Doesn't matter if you're a parent trying to decide for your own children whether or not they can handle these magnets. Didn't matter if you're a professor trying to demonstrate molecular bonding or show platonic solids. Didn't matter if you're a college student in a dorm. Here in America, it's like at the age of 21, you can buy a handgun, you can drink alcohol. At the age of 18, you can smoke or buy tobacco. You can buy a rifle at that age. You can go fight war. You can sign contracts at 18. 16, you can drive a car. 14, the minimum age of employment. Age 8 is when the Consumer Product Safety Commission expects your children to be able to read and follow warnings. But apparently at no age do they think it's reasonable for anybody to have these magnets here. It's too dangerous. Never really got that.
Now, it's not true at all. The magnets can be used for any number of things. We hired experts. Shihan hired experts to show, one in particular, Dr. Boyd Edwards, who is as close to a Renaissance man as you'll ever find. He's an accomplished musician and composer of classical works. He's a physicist. He's a physics professor. He is a numbers guy. He and his brother write articles all the time. They are brilliant people. Dr. Edwards testified on our behalf that these magnets are great. I can do so many things in my physics classes to show children how physics works and how biology works. Why? Because those of us who might have gone to school in the dark ages when we learned molecular biology and chemistry, so we had the little ball and stick models to show how things group together. Does anybody take, right? With these magnets, Dr. Edwards showed us how a student can see in actuality how these things can work together. Not only that, we had another teacher in a very exclusive private school in California who also came and testified in a deposition how these things can work so well and how beautiful they are. We had parents say, my ADD children work with these magnets. It's therapeutic. It's beautiful. It's wonderful. Don't take these things away. Because, yes, there are risks if someone swallows them. That is, by the way, the only risk. If 2 or more magnets are swallowed, I don't recommend it. I wouldn't even try it. Okay? Do not do that. It will probably not work out well. Okay? But don't swallow them. So they had experts, one in particular, a Dr. Steinberg from the University of Pennsylvania, a national recognized scientist, right, part of the United States elite in science, comes and testifies that these are kids, Kids do what kids do. What do? They take the magnets and their parents don't let them pierce their tongues. Shame on the parents, right? Because we don't want our kids running around with pierced tongues. So, okay, mean mom and dad, I'll show you. I know that there's a thing out there, these very strong magnets. I'm going to put one on the top of my tongue and one on the bottom of my tongue, and it'll look like I have a pierced tongue. Okay? Because that's how strong these magnets are. They can stick together through the tongue. Only sometimes not. Sometimes someone will laugh, which happened, and they swallow the magnets by accident, or one student is giving to another, so we've had those kind of cases. There's a few of those cases. So again, Dr. Steinberg says, well, you're never going to stop a child from doing that, child meaning anyone up to age 18, because they'll do what they want to do. No warning in the world. They hired a human factors specialist named Dr. France to come and testify that there's no warning on the planet in any language, written in any way, that will ever work to stop a person from swallowing these magnets. All right, that was the deposition testimony. The trial testimony was the same. In December of 2014, 4 years ago, we go to Bethesda, Maryland, in the hearing room of the Consumer Product Safety Commission. Now, they're an administrative agency. They have commissioners. They have a hearing room. We tried the case there. The judge who tried the case was, when I say judge, am I talking about an Article 3 judge? No. We're talking about an Article 2 administrative judge named Judge Dean Metry. He was a Coast Guard judge. The Coast Guard is part of the Department of Defense. The Department of Defense Administrative Agency. Every administrative agency has judges. All right? He heard Social Security cases. The Social Security Administration has judges. We have administrative judges here in Colorado. Anybody gets stopped for a moving violation of some sort and You get lost points on your license. You got a notice in the mail that if you challenge this, you can go to the Department of Motor Vehicles. Department of Motor Vehicles is a state administrative agency. Disputes with the Department of Motor Vehicles are determined by an administrative law judge here in Colorado. Okay? Not an Article III judge. You want to challenge your ticket, you want to challenge careless driving, any of that, yes, that goes to an Article III judge. What we would call. The state constitution is a little bit different than the federal constitution, but just so you understand what we're talking about, judicial versus administrative. All right, so we tried this case before Judge Metry, Coast Guard judge. Great guy, good judge. We're there for 3.5 weeks. I think Shihan might tell you it was one of the toughest 3 weeks of his life up to that point. It was a trial. Anybody who's been in trial knows we worked very hard. To Shihan's credit, we were working pretty much from Saturday night to Friday afternoon. Now, I'm a Sabbath-observant Jew, so we had to stop early Fridays. I went and found places for the Sabbath, but then we got back together Saturday night, and we worked. When I say we, I also have an associate named Evan House, who came with us to Washington. Evan did great work for us all the way along. Part of the case involved a lot of drafting and writing. So we have this trial in December of 2014. During the first day of trial, I filed my notice of appeal of the rule. Remember the rule? Don't forget the rule. You still got that going. Before the rule takes place, I file a motion for a temporary restraining order so it won't become effective. They grant it for a whole week. The government writes back and says, nonsense. The 10th Circuit Appeal, the emergency panel said you're right. So now the rule became effective. Okay? So that's in April of 2015. We briefed the case. Now I'm in the 10th Circuit. Now I'm talking about the rule. And in November of 2015, I argued the case. We have a 3-judge panel. I don't remember the other 2 judges. One of the judges was Neil Gorsuch. Okay? So we're the 5th submission. We start at 11 o'clock. We have a half hour. I get 15 minutes. The other side gets 15 minutes, and that's it. To brief why, to explain why the rule should be, in our case, vacated. The government argued why it should be kept. And the reason I mention this is because these are bright people. People who serve as circuit judges across the United States are very bright people. Make no mistake about it. You may not agree with them, which is perfectly fine. If you have strong arguments, one way or the other, it's perfectly fine. We began the argument that morning. Your Honors, my name is David Japha. I represent Zen Magnet. Shihan was out of town that morning, but Evan and I were there. I introduced Evan because he was with me on the brief. I finished and said, this case is about these magnets, and we don't believe that the procedures used by the CPSC to promulgate the rule. Judge Gorsuch, out of the box. Mr. Japha, how do you see this case in terms of the Chevron case? And Chevron, you might have heard about this case. I'm going to give you the exact site, if I can here. It is a case that was decided by the U.S. Supreme Court in 1984. 6 justices of the United States Supreme Court made a determination that where a statute or a regulation is ambiguous, the administrative agency itself can determine how to interpret the statute. Okay? And that was 1984, and it flowed naturally from prior administrative law cases. Okay? It is that case that Judge Gorsuch, now Justice Gorsuch, he has written about, and he finds, and many people find, bothersome because of that power that it gives an administrative agency to determine its own regulations. Okay? Now, I'm just going to read from an article. This is Chevron USA versus Natural Resource Defense Council. It's 467 U.S. 837. According to the author of this article, Linda Jellum, a professor of law at Mercer University Law School, they dramatically altered the executive's power to make and interpret law. Okay? Meaning, prior to Chevron, Congress had the primary responsibility for lawmaking, while agencies made policy choices primarily when Congress explicitly delegated that power to them. In short, prior to Chevron, the executive was an expert advisor, not a lawmaker or a law interpreter. With its holding in Chevron, the court dramatically and likely unintentionally altered executive lawmaking and interpretive power, specifically executive power burgeoned. Now, she argues that in later cases that has been drawn back a little bit, and because of people, judges like Judge Gorsuch on the circuit courts, and he was appointed 10 years prior to, I believe he was appointed by George Bush, President Bush. There's been a drawing back of this. Why do I mention that? Because his first question was, to what degree does the CPSC get to determine how its own regulations are applied, in our case, to these magnets? Okay? So I answered it that I think they do, but we had a bigger problem, and that was how they use the science to come up with their rule. And it was on that point that the court agreed with us, and in November of 2016, almost 2 years ago, the 10th Circuit Court of Appeals vacated the rule based on our arguments, and in a 2-to-1 decision. Okay, Judges Abel and then Judge Gorsuch ruled in our favor, and the other judge, whose name I conveniently forgot, ruled against us, or would have ruled against us, but we win. 2-to-1 is a winner. Okay? So the rule was vacated. So that's great news, because now Shihan can start importing magnets. But we're not out of the box, because remember I told you that the CPSC sued Shihan for allegedly violating the consent decree. We resolved that matter later in 2016 also. But more importantly, in March of 2016, Judge Metry, remember Judge Metry, the administrative law judge from the Coast Guard, also ruled in our favor that the CPSC had not adequately proven that these magnets are a safety product hazard, and therefore, from a period of time after warnings were put on packaging, that there would be no recall of those, and there'd be no stop sale. In essence, we do a little victory dance, because that puts Shihan back in business. Okay? Because the judge found, the administrative law judge found, that the agency did not prove their case adequately. They were arguing that the packaging, the warnings, anything was no good, and these are a product hazard, a significant product hazard, and they should not be in the marketplace, and they should be recalled, and any further sales should not be done. Great. We win. But now, the complaint counsel, who's the lawyers, sort of, for the CPSC, and I'll explain that in a moment, they file a notice of appeal according to the administrative law rules, which are proper. And I know most of you in here, if not all of you, are going to say, what? When I'm about to say? So to whom do they appeal? Themselves. They appeal to the commission, to the Consumer Product Safety Commission. So as soon as we get the notice of appeal, I'm thinking, I wonder if I'll win. I don't think so. I'm sure we'll lose. But, fortunately, the commissioners were not reticent about all the terrible things about magnets. And so already before the case went forward to trial in December, in September of 2014, I filed a motion to dismiss the administrative complaint. Why? Because I already know how they're going to vote if we should win. Even if Judge Metry rules in our favor, I know what's going to happen. How do I know? What, do I have a crystal ball? I don't have a crystal ball, but I have the statements of the commissioners themselves. Not only from the rulemaking, where they make a whole record, and it's all in the Federal Register, which is the record of all administrative agencies, all right? But they had press conferences, and they made what we would call out-of-court statements. These were people who were supposed to be objective, and they were telling how wonderful it was that the magnets are banned, and how wonderful it was that there's this complaint. One of the commissioners, who is now the chairwoman, said, whoa, you can't do this. How can you prejudge this case? I filed a motion with Judge Metry to dismiss. He says it's premature. Let's see what happens. And he rules in our favor a year and a half after, and we finish in December of 14. He rules in March of 16. They file their notice of appeal. So now I file a motion either to stay the proceedings or you can't win. You gotta recuse yourselves. All of you who made these statements, I laid it all out in documents. And Evan was great. We have news reports of everything they said. Okay? Okay. Anybody here want to guess how they ruled on that motion? You're right. I won. No, I lost. Big time. We're going forward with the appeal. Okay, fine. We do our appeal. We file massive amounts of dead trees. And for those who enjoy the environment, legal work is not for you. There's a lot of paper. So we file it all. And the Consumer Product Safety Commission, interestingly enough, is one of the few administrative agencies that so far has not come to the 20th century, and you still have to mail everything in triplicate to the secretary. Okay? Now, Judge Metry, to his credit, said you can email me, but the rules is the rules, and you got to follow the rules. So, the copy machine's going at the last minute every time we have to file something. Right? And so reams of paper are being mailed to the Consumer Product Safety Commission. I'm sure now they occupy great space in filing cabinets doing nothing. But that's for a different day. Now, we're back here in the appeal. In June of 2017, we have an oral argument. Now, I'm a simple small-town lawyer. I come from Denver, Colorado. I'm thinking oral argument. I have done oral argument many times in many courts of appeals in the United States. Well, I've never done an oral argument in front of the Consumer Product Safety Commission before. And it was more like a congressional hearing than it was an argument of the kind where I had argued in front of the 10th Circuit on the rulemaking, for example, where you state your case, the judges ask questions, you hopefully can answer the questions, then you sit down. Good night. Okay? That's not how this worked. We had an opening statement, and we showed them the magnets, and then each of the commissioners had 5 or 10 minutes or whatever it was. I don't remember the exact timing anymore, but they could each, beat up on us depending on their point of view. So it wasn't like informational questions like why, when, where, how. It was like, well, don't you agree with? And so depending on the makeup of the panel, which was in those days still 3 Democrats to 2 Republicans. Okay? So again, after the oral argument, it was no secret who was going to win and who was going to lose, because I think we'd all agree that if you get to decide your own appeal in your own case and you felt that you were righteous in bringing your case and you lost it, and then they came back to you and said, well, what do you think? Should you lose or win? I think all of us in here, for honest, are going to say, well, of course I'm going to win. I wouldn't have brought the case if I thought it was a loser, right? They're not going to say, oh, Judge Metry's right. They can't do that, right? We wouldn't expect them to. Now, how is it then that administrative law works that way is because we, generally speaking, this case notwithstanding and others, we depend on administrative agencies for a lot of stuff in our life, all right? We may not like it. We sometimes feel they overreach, and when they overreach, we have these processes that we can use to go forward. So what do we do? September of last year, September 2017, we get the surprise of a lifetime. Not. The Consumer Product Safety Commission reversed Judge Metry, and they've now made what's called a final rule and order, final rule and decision, but now we get to go to a real court, an Article 3 court. Here, what the commissioners determined, what Judge Metry got wrong, was the application of the regulations to the magnets. For example, a point he made was, these magnets do exactly what they're supposed to do, like a knife, which is an example right out of the regulations, okay? We don't ban knives because you get cut by a knife if you misuse the knife, right? What the commission did on doing that by Judge Metry was said he misinterpreted, he misunderstood the regulation and the magnets, it's not a matter of misuse, it's a matter of foreseeable misuse. So because you can foresee that a teenager is going to want to mimic a tongue piercing, because that's what all teenagers do, so that's the problem. So one of the commissioners and I got into it when, in June of 2017, when we were there doing the oral argument, we got into it. What's foreseeable misuse? I said, frankly, and you can, this is on YouTube, I said, well, if we're going to go that route, we all might as well just stay home, because life is full of challenges and there's risks. And if that's how you're going to start making regulations, then it's, in this case, it wasn't a regulation we were arguing that. But that was their primary focus, that they went through and determined that Judge Metry had made certain mistakes in terms of understanding the application of the facts of our case to the CPSC's regulations. They cited prior cases, that sort of thing. We file a case in the United States District Court for Colorado, because that's where Zen Magnets is. We sue the Consumer Product Safety Commission. A number of violations that we said were constitutional violations. Chief among them was, where's the due process here? I didn't know that we were going to lose simply because it was the Consumer Product Safety Commission. I knew we were going to lose because the commissioners told me so to my face in the news, in any number of writings that they had, any number of things that they put out there. And we went through point by point. Now, this case was before Judge Jackson in the U.S. District Court here. He was appointed, I think, by President Obama. Wash my mouth out. By President Obama. But he's from Jefferson County, and he's a fine judge, actually. I appeared before him in state court many, many times. He was a state court judge for many years. But now here's an interesting twist to the case that's kind of fun. No judge. See, what happens in the U.S. District Court, once a case is filed, it goes to all the sitting judges. And if you're a retired judge, you can decide if you want the case or not. And interestingly, our case went to a number of retired judges. When I say retired, they're senior judges. They're not retired. When I would think the best job on the planet Earth is being a senior U.S. judge. Why? Because I get all the perks of being a U.S. judge. But I don't have to take a single case if I don't want to. And I get chambers. And I get staff. And I can come to work when I want and when I don't want. Now, frankly, any U.S. judge can do that. But the reality is, any U.S. judge, almost every U.S. judge I've ever met or appeared in front of are like type AAA personalities. And they just don't work that way. So you don't have to worry. I mean, they don't get to be where they are by being lazy. It just doesn't happen. Now, there are some exceptions, but they're very rare. And so, bless his heart, Senior Judge Mach, I just know those of you, Timothy McVeigh case, right? He was the presiding judge in that case. But I've tried many cases with Judge Mach, and I've known him a lot of years. He's a wonderful man, and he's a great judge. But he's no youngster. And he has no reason to be coming to work every day, but he does. And for recreation, to blow off steam, he cuts wood. So I figure when the good Lord comes for him, he'll either be cutting wood or he'll just fall off the bench. One of the two. Because that's what he does. And most judges are that way. Okay? Just to let you know. They're workers. But senior judge, but one of the prerequisites of being a senior judge is I don't have to take this case. So it went to 3 senior judges on the U.S. court, on the district court, before finally Judge Jackson accepted. We had all kinds of things to do. We had to do. Anyway, Judge Jackson ruled in our favor in an opinion that came March of 2018, something like that. And it's still pending because there's part of his opinion we didn't really like, and so we filed a motion to reconsider. And that's still pending before Judge Jackson. And so the case goes on because we've also filed a request of a new rulemaking. Why? Because in one of the great twists of life, one of the great ironies, so there's no recall for Shihan or any other company that doesn't have a consent decree, which is many. There's no requirements for any rules or packaging because there's no rule making because we knocked that out and they haven't gone back to make a rule because they can't because of the problems that the first rule showed. So now any company who wants to, and I'm not suggesting anybody in here does this, can sell high-powered magnets in a plastic bag. And they do, without warnings, without notices, without anything. And so the market's a difficult market. So the effort, because, and here's the bottom line for this group. I tried like mad to resolve the case by saying, here's what we'll do. We'll put in warnings. Shihan invented great packaging so that you have to be, probably 40 before you can figure out how to open it. All right? It was no, because you get, it's krypton, and as soon as you get near these magnets, you will die. So we're not dealing with you. And that's where it stands right now. And that's our experience. So I'll turn it over to Shihan.
I was going to talk about some, chronology, but I don't think I need to after that. I think pretty much covers it. The company was started with like $800 of seed money 9 years ago, but of course it's been basically my full-time job since before I graduated college. The lawsuit itself, of course, there's been a lot of monetary expense, but at times it can be very time-consuming. It comes in bursts. It seems like there's a lot of waiting around. I remember when I first got sued, when I first received the administrative complaint, and before I had met David, there was a time in my life I thought that I would valiantly do this myself, and I would just power through it and just put all my mind power and it'll be fine. I'll handle it. I was I had no idea. Very surprised to come up on top, but thanks to David, still selling magnets. Let's see, things are not covered. Perhaps why I guess I kept fighting. Hard to say. I didn't really expect to win. I think David himself told me that I wasn't going to win. I'm pretty sure every lawyer that I talked to told me there was no way I was going to win. But it seemed offensive to me to just let this pass. So I was kind of more worried about the sleepless nights, regretting whether or not I could have done something. And plus I'm like young, and if I lose everything, it's not that big of a deal. Those are the kind of things that were in my mind when I decided to fight this whole thing. So it's not like world changing. It's not causing huge waves or anything. It's just a small corner of the consumer product world that we've been fighting over. But I think we've had some good results with that.